Hi, everyone. I am very happy to be here. I'm Heather Dembert Rafter, full name. And this is one of many panels we've done for Audio Developer Conference. You can Google ADC and find our other legal panels, or just get in touch with me and I'll give you information on the past ones we've done, including with Francine, who Brady Bunch style is right below me. We, of course, as lawyers, three of us are lawyers on this panel, want to give a disclaimer that we're talking about hypotheticals today. The views we're expressing are not legal advice and not necessarily those of our clients or even our own. So how's that for a disclaimer, Philip and Francine? Does that work? Okay. We have three lawyers on the panel and two entrepreneurs, CEOs. And today we are going to try to give you tips for how to think about negotiating agreements. It would be very helpful if we had a show of hands in the David and Goliath fashion. How many of you are small developers that are looking to license your plugins or technology? If you could show your hands, that would be really helpful. Raise your hands on the screen. And Josh, can you see how many people are representing the more David style developers?
Yeah, so we have 11 participants who have raised their hands so far.
All right. And how many of you work for large companies that are out there scouting for these fabulous David style smaller developers to get their technology to distribute or use in your products? And what's the final tally on that one?
4 people.
Okay, well, this is great then. We will focus a little bit more from the perspective of the small developer. And let's think. Any other questions, Philip, we wanted to ask? Was that the primary questions?
I think that's a great question to start with, so we can go from there.
Okay, terrific. And okay, my name is Heather Rafter again, and Heather Dembert Rafter, and most people knew me originally. I'm long in the tooth in the audio industry. I was the general counsel of DigiDesign, which makes Pro Tools and is now part of Avid Technology. Has been for a long time. I was there for 14 years. Since then, I launched my own law firm, which I'm proud to say Philip is part of, and it's called RafterMarsh. We're both in the UK and the US, and we represent many, many wonderful audio companies. If I list a few, I will be afraid of forgetting others, so I'll leave that to Philip whether he wants to mention them. They're in our bio, but most of all, we are proudly lawyers for Dirk, which it means Brainworks and Plugin Alliance. And so Dirk was kind enough to join us today, so I'll pass this over to him to do the intro for him, and then he can pass it on to someone else, because I really do feel this is Hollywood Squares or Brady Bunch right now. Okay, thank you. Oh, and I'm also dual qualified. I'm licensed in California and also England and Wales.
Okay. Thank you, Heather, and hi, everybody. I'm Dirk. As my cheesy background picture suggests, I live in Florida now. I just moved from California, and I am the founder and CEO for both Brainworks in Germany and Plugin Alliance in the US. And one of our partner companies here, Adapter Audio, is actually presented in this panel as well through Mark Adamo. And maybe I'll pass on to Mark, and then he can pass Francine, I guess, so we don't forget about her.
Hi, everyone. I'm Mark Adamo from Adapter Audio. We're a young company, about 2 years old, and we make 2 plugins at the moment, Metric AB and Streamliner, which are distributed through Plugin Alliance. That's us. So over to Francine next.
And everyone has a nexus. I wanted to say I've had to negotiate against Francine. So there you go. All the power to Francine.
Hi, everyone. So I'm Francine Godrich. I work for Focusrite, who is probably one of the Goliaths in terms of industry. But actually, we are one of the companies that are out there scouting for plugin developers all the time. And we get to meet some really fabulous people who come across us with what they want to do for us. And yes, I've negotiated with Heather. I'm still alive. I've lived to tell the tale. And hopefully today I can pass on a few tips to you how to survive.
And Focusrite was one of the most prominent partners of DigiDesign way back when. So we have to give a quick shout out to Phil Detterage. Okay, chairman of Focusrite, who I've known forever.
Yeah, it's a pleasure being here, as Heather already mentioned. I work with Heather. I'm an attorney based in New York, so I somewhat took right the middle of the time zones as my spot of where I practice law. So all my colleagues are either in California and in the UK, and I'm based in New York. And I have a law degree in Germany and passed the state exams there. And but I'm practicing US law on behalf of RafterMarsh, and working with many great clients such as Dirk's company, especially when we deal with cross-border transactions. And as we all know, we're dealing in a business that is not only inside our borders of our local countries. It's quite of an international topic we're discussing. Thank you.
All right. Well, we're going to try to, in 40 minutes now, 43 minutes, try to teach you everything you need to know for negotiating these agreements. Normally, you would hire attorneys, and hopefully you'll still think that you might need them. And we're going to try to condense what might take days and days to down to a quick panel. So I think before we go into a legal checklist, which we've prepared, it would be really helpful to take a step back and have Mark lead us off, because there's so many smaller developers here, to talk about, from an entrepreneurial perspective, how you even think about going about licensing and working and collaborating with a larger company versus kind of going it alone and never licensing out, just selling direct.
Okay, so with Adapter, we've never really licensed anything out yet. We've literally created all our products in-house. And then we've got a distributor, which is Plugin Alliance, to actually handle all the marketing, sales, distribution, tech support, and all those kind of areas. So we can just literally concentrate on developing plugins and stick to that stuff without getting distracted by all the other stuff.
And how's it going? Do you have any thoughts on lessons learned and success stories, why you've gone certain paths versus others without, making it too obvious? You're obviously decided to go with Dirk and Brainwork's Plugin Alliance. So okay. Plugin Alliance.
Yeah, let's keep it clean. Let's say I had some experience with other ways of releasing plugins before, and I guess I learned my lessons. And the real thing was, you got to find the best distributor in the business. If you've got something really good, then aim for the best. And really, there's certain criteria that you want. You want a company who has a great image, a great customer respect. They release great stuff, and the internal workings of the company is good as well in terms of, there's proper people assigned to do every aspect of the jobs. There's good contacts who you can speak to directly about different aspects, whether it's technical stuff, marketing, accounting, anything like that. And you really just want to make sure that your product gets the best start it can possibly get in this industry, because it's very competitive, and you really need to find someone with good profile, good reach, and give your plugin the best chance of getting out there.
Okay, well, one of the things we're going to talk about when we get to our checklist is how important it is when you are a company trying to license out technology to make sure that your intellectual property you've created really belongs to you. So I don't know if you've had how that works, or if it's people on your own team that have been developing, or if you license in third-party technology. Are there any tips on that you want to share with everyone?
Well, we've never really licensed anything in that's created by another company. All the designs originated with some ideas I've had, and then we have a team of developers who work to those specs to build up the stuff. So essentially everything in Adapter is in-house designed. And then, yeah, that's it really. And so we kind of own all the IP Adapter, and it keeps it simple, really.
All right. Well, one last question for you, and we'll switch it over to Dirk. Were you, since you've had a lot of experience now signing these licensing agreements, are they about as much work as you thought they would be, or do things go pretty smoothly?
What, like the distribution deals?
Mm-hmm. Yeah. And do you have your own lawyer? Do you bring your own lawyer to look them over?
Yeah, I mean, the contract with Plugin Alliance was pretty fair. In fact, the kind of things you really want to negotiate aren't so much negotiations, but really due diligence. Like, the kind of things you might need support-wise as a new developer. I wouldn't really argue about percentage points of, sales, royalties and stuff if that's pretty fair. The more important stuff is things like, Q&A. Are they going to help you get your plugin to such a high standard that you're not going to get much problems when it goes out to the customers? Because that's a really important step for your brand to have a very reliable name. And, if there's a team at Plugin Alliance which help do all the QA and ensure that everything is about as good as it can get before it goes out into the world. So that kind of stuff is actually invaluable if you're a small development team, because, the scale of the in-house team that do all the alpha checking and then the scale of the beta testing they do is really good. So that kind of stuff, invaluable. The other stuff you really want to think about is marketing. I mean, establishing a new company name in the audio industry is pretty difficult. You have to have a killer product, but also the way it's presented to the public needs to be top notch as well, really. It can't be just, here it is, here's another plugin, 50% off today, do what you want with it. You really need to have the right reach. You got to have the right message. And it's important to construct that with other people because, you get different perspectives on things. Like you might think my plugin's all about this, but someone else might say, hey, have you thought about it applying to this way? Or we think, for instance, that these artists would be really great as ambassadors for your plugin, endorsers, and you might not have the reach to reach them, but someone like Plugin Alliance does, and that's another great facet of it.
All right, well, thank you. So we will now segue to the semi-Goliath in the industry, because on behalf of Brainworks, you're negotiating with larger companies. But on behalf of Plugin Alliance, you are the distributor. So if you want to give us some of your thoughts from both those perspectives, Dirk, about your experience out there working with lawyers and licensing in technology, and also afterwards talking about some of the distribution deals you've done with other companies.
Yeah, happy to do that. And as you just said, so we have to separate Brainworks here from Plugin Alliance. Brainworks has a lot of agreements with companies like SSL, MPEG, even Focusrite, and all these guitar amp and console and compressor companies. And we basically license the right to make a plugin that sounds and looks like the original hardware. Most of the times we get the schematics. If there are patents included, we get access to the patent papers. And one of the most important things, we get access to the developers of the original hardware to make sure that we actually create something that's very credible in terms of representation of the original unit. With Plugin Alliance, you're right, we've become in the last 10 years or so one of the bigger plugin companies, I guess. And even though we're not as big as some of the real Goliaths maybe in this industry, I think when we talk about companies that only sell plugins or exclusively plugins, we're probably one of the biggest right now. And in that matter, we actually do work with smaller companies. So we're the big company in this case, just like with Mark. And I'm happy to hear, Mark, that you actually value what we bring to the table, because I like saying that Plugin Alliance is not, we don't see ourselves as a distributor for plugins. We are more like a standard or like a system that people subscribe to even. And then we like to bring in companies that are unique, and we request exclusivity for that matter, which isn't always an easy step for a small company to do. There's a lot of trust that we ask for, of course. I mean, obviously, if you sign your company to Plugin Alliance exclusively, and then if we would suck in selling plugin generating revenue for you, that would be a real problem for you as the developer, because you couldn't go somewhere else. And so far, we've managed to do that, I guess. And the difference that I would like to point out is that there are companies that distribute everybody's plugins, and it doesn't matter which DRM these plugins are using, whether it's their own system or a standard like iLog, of course, or just the challenge response code that a developer came up with. And they can generate some revenue, I guess. In our case, we are one system. It's the same DRM. And that's very important for us. And we do a lot of the marketing and all that stuff that Mark has already pointed out.
So, Dirk, before we go to our legal checklist, just wondered if you had any thoughts about sort of lessons learned in negotiating with larger companies with distribution deals. You actually did a deal with Francine, so only say kind things about working with Focusrite.
Yeah, and that's true. I mean, everybody I met so far in Focusrite, including the founder, was really pleasant to be with and to work with. And in the case in Focusrite's case, we actually have a very creative contract with this company, which I'm of course not going to go into the details, but it was rather fun to work out. And one thing that's really interesting is that sometimes the smallest companies or developers that you talk to, that's my experience, have the highest demands and sometimes the craziest ideas. And I'm not sure if that's maybe because of a lack of experience just in that matter. In general, I always like to take it really easy and just meet with somebody that wants to maybe become part of the plugin alliance, talk about the terms. There are certain things that are negotiable. There are certain things that are negotiable maybe only within a certain range. And then there's stuff that's just not negotiable if you want to become part of a system that has 30 plus companies as part of it. And so I guess it always starts with the human interaction, really. And if you like somebody and they want to work with you, usually these deals happen. That's something I can say.
All right. Well, we're going to transition now and let Francine and Philip hopefully dazzle and explain a lot of complex topics, but we want it to be interactive with you, Mark and Dirk, on these topics. So there's always a question about what point to get lawyers involved. And why don't you think about that and answer that question, Francine? And Philip, did you post the link to our document?
No, not yet. So just to let everyone know what Heather is speaking about, we prepared a legal checklist with some items that may or should be considered in any kind of B2B, meaning business-to-business audio licensing deals and transactions, which I'm happy to share right now. It's a Google document. I believe attendees only have viewing rights. Otherwise, we can all collaborate on this and even add additional items. Let's see if this works. And
for those of you on YouTube, will they be able to see the link out there? Josh, do you know?
No, they will not, unfortunately. But I can, if you can actually just send the link, I'll actually paste it into the live chat.
Okay. It's in the chat box right now. So, okay, this question about when to get lawyers involved, and Francine, you want to kind of toss out your thoughts on that? You're in-house counsel, so you're not pitching yourself for services. So what do you think? What advice do you give to smaller developers?
So I guess if you're really small, it's going to be as late in the day as possible. And I mean, from Focusrite's point of view, we've had developers who haven't had lawyers at all because they are so small, they can do it themselves. One of the sort of important things to have sorted out before you get your lawyers involved, I think, is the commercial terms being agreed. So by that, I sort of mean pricing, the timescale for developing the product, who's going to be doing what on which side. Because with the best will in the world, lawyers don't understand what it is you're doing. I've worked for Focusrite for 2 years, and I still go around looking at physical plugs that I plug into a wall when people talk about plugins. And secondly, we can spend days and weeks talking about an extra couple of cents here or a couple of cents there for doing something, but you will never get that value back in terms of like what your lawyers charge you. You'll never make enough money to cover the cost of your lawyer negotiating that for you. So I'd have that sorted out before you get a lawyer involved. The other major thing from my point of view is having your ownership of your intellectual property sorted out. So making sure that the people who are working with you, either on an employed or a contractor basis, they are assigning the IP to you correctly. You know that the IP is unique to you. It's not copied from anywhere, because a sort of IP litigation is one of my big fears. If there was anything that kept me awake at night, it would be the thought of someone coming after me for IP infringement. The other thing to think about before you get your lawyers involved is support for the product, because it's all well and good making this product, developing it, launching it, but what happens sort of in a few years' time when it's kind of old and rusty and not really working much more, or you want to disable it? What does the company who's buying it from you, what do they do about making sure that their customers are still happy? So sort of have an idea of the life cycle of your product and what you can do and how you're going to get out of sort of being tied to a company forever by having to continually update or fix bugs in plugins.
Okay, so you can kind of see it here. Do we all agree that we should have people look at it individually and just continue to talk round robin? Is that the agreement? ADC team, our checklist, Philip?
Yeah, I think we can continue this discussion, and I'll encourage the audience to not take a close look at the checklist yet, because you will find more time after this panel, but we can speak about a few items that we'll find on that checklist.
We're going to zoom through in 20 minutes. Do you want to start doing it, Philip? Talking about at the top of our checklist?
Yes.
Zoom.
Of course. Before we zoom right into the checklist, I just want to add, and that is actually the first part of the checklist. So why don't you open the checklist? It's the Google Doc that the link has been provided. When we ask ourselves, when do we get lawyers involved? The question is, when do we get lawyers involved in the background? And I do encourage everyone, and that's not only because I'm a lawyer, I do encourage everyone to consider some of the key items in the background. That doesn't mean you bring your lawyers to the negotiations when you reach out to someone like Dirk. Dirk will probably, we'll ask him how he feels if he comes approached with a couple of lawyers in the background. But regardless, you want to consider some of these items that Francine has mentioned, right? Are you actually able to license whatever you're thinking and considering about the license to your potential contract party? Another thing that you may want to consider, right, in a conversation, what are you going to disclose? What kind of information are you going to provide to the other side? Is there going to be some confidential information involved already? You may want to consider a non-disclosure agreement and executing before that. Also, some of the, before you get into the real deep paperwork of an agreement, and we'll look into some of the key items that you may want to consider. A good idea is always to come up with somewhat of a term sheet. And these are non-binding papers. They have all sorts of names. It's a memorandum of understanding, MOU, letter of intent, LOI. In the UK, they often, you guys often like to call it HOA. There are these, basically this is
heads of terms too.
It's just the key terms that you want to consider before you take all the time and invest the money into lawyers writing up all the legalese to make sure that everything is okay and doing all the due diligence, because maybe there's already a deal breaker. For example, a question like exclusivity or not, or the payment terms, etc. But yeah, and Heather, do you want me to? Oh, go ahead.
Yeah, I was going to say the first thing is usually you'll have a confidentiality agreement, and then you'll have some sort of term sheet, non-binding term sheet, which again is called different things in different jurisdictions, and that you can really work on yourself. So normally, what would happen, right, Mark? You and Dirk would pound that out on an email, and whether you would formalize and sign it, you might or you might not. But
yeah,
right when.
I was gonna add that sometimes people think that lawyers do the negotiations and find the terms, and that's most of the times that's not true. I will talk to either a licensing partner or to a company like Mark and discuss and negotiate basically what the splits is. Somebody just asked that question here in the Q&A section. What is a typical split, for example, for a distribution deal? And that's not something that the lawyers will fight over. Basically, Mark and I will tell either our lawyer or to both lawyers, if there's two companies involved, and say, look, we want to work together for 5 years, and Mark is supposed to get 90% of all the royalties, which he's not. But
that's a very strong David. He's got a good slingshot there. Yeah.
But basically what you tell your lawyers, and then they put it into a legal and binding form. And that's maybe something that Mark and I couldn't do by ourselves. And sometimes they have really good tips saying, you know what, you should include something. Have you thought about what would happen if you ever don't want to work together anymore? And how would you split and stuff like this? Sometimes when you start a relationship, then you're really excited about it. And sometimes you forget to think about, well, how could it and how would it end someday? And so that's important stuff. And this is where I really value the legal company coming in and helping. But I would never expect the legal company to get me 5% more in a deal or something like this. That's most of the time.
Thank you, Dirk. So it's really helpful. Everyone would agree, Francine, Philip, and I, when the person who gives us the project to work on already has the business deal terms worked out. It really makes it much more efficient for everyone. And, you know, we might have some input, and we're going to talk about there's different ways to structure a licensing deal. So I look forward to Philip and Francine in 120 seconds talking about all the different licensing structures. Can you wrap it or something, Philip?
Double time, yeah?
All right, let's go. Let's start all the different ways. We're talking about different ways you can license and get paid.
Again, every deal is unique, right? So I won't be able to wrap this, by the way. I'm going to try to speak as fast as I can. Every deal is unique. So it already starts with the question, what are you going to license? Are you going to be, you know, providing certain deliverables, right? Like Mark, he's doing everything in-house. He may have employees. He may have independent contractors who are working on behalf of him and are transferring whatever they're working on, that kind of IP, intellectual property and ownership, to Mark's company. So Mark can then, you know, license it to a distributor like Plugin Alliance. You may want to be an independent contractor for a firm that is doing particular services, you know, providing software. So again, it depends. But if you are developing a product and licensing that to someone, there are a few additional things to consider. For example, as always, the most important part, payment, right? How are you going to get paid? Are you going to just sell your product basically, and it's you get a flat fee or a buyout fee? Are you going to be just like an employee or a contractor who gets paid on an hourly basis, no matter what you basically do? Or are you going to get your money as soon as you provide a finished deliverable? There are also other models like a royalty share model where you can either get a percentage of the revenue, and then that's when you have the lawyers come and join to discuss how are you going to define, for example, the net revenue, right? The net revenue after deduct all the additional. I think Dirk can also speak about this, but that's always a question where you need to be very specific, obviously, because at the end it's always about the money.
Refunds, returns, rebates, marketing fees.
Exactly. Or do you maybe need an advance, right? So if you think you have a really good idea and you need some cash up front in order to finance this idea and to pay your contractors and to pay yourself, larger companies may be interested in giving you an upfront payment that is recoupable afterwards, if you do, for example, a revenue share. And then we spoke. I mean, there's so many. You can
sometimes
go through the list.
Sometimes if you're a developer in need, you'll want to negotiate as Philip said, an advance payment up front. You might want to get a lot of money in years 1 to 3, and then agree it caps out at some point, and then they can keep selling the product. There are so many different permutations on licensing strategies and getting paid. And our job as lawyers is to speak with our clients and try to figure out what's best for them, right? And
which brings me, absolutely right, which brings me, for example, to the question of exclusivity. Are you going to license your software or product exclusively to your contracting party? And then as soon as you have, for example, an exclusive license agreement, you need to consider for how long, what's the term? How long are you going to be bound? And the exclusivity, is this only about the product that you're going to license, or is this maybe even for future products? These are some of the questions you need to consider. And of course, depending on more the more you're bound via exclusivity, the more you also have a right to negotiate maybe a higher fee, or it always depends.
And how do you just define exclusivity? Is it exclusivity in the pro audio market? Do you also do you have the right to use your technology on an app or in gaming? I know some of you are game developers. This is where speaking with counsel and coming up with good thoughts on all these topics, I believe, is helpful.
And there's softer versions of exclusivity too. If you don't want to, if you don't want an exclusive agreement just yet, but you do have faith in that potential relationship, you could come up with concepts like the right of first notice, which basically means if you, for example, have an upcoming product and you give that contracting party at least notice to say, hey, look, I have this. Are you interested? I'll tell you first. If you're interested, you can take it. Or a little bit tougher version is the right of first refusal, which allows basically, the contracting party to have the right of way whenever someone else is offering you a certain deal. Then your contracting party which has the right of first refusal will get a chance to execute an agreement that is, has the same deal terms and same rates.
And sometimes Dirk can tell you, sometimes people will come and say, hey, I'll be exclusive, but I still want to sell on my own website. So there's just so many different ways to slice and dice these deals.
Mm-hmm.
Yeah, for example, we regularly carve out the websites of the individual developers. If they want to sell their plugins on their own website, that's fine. They will still use our DRM. So basically they sell something, they sell a code to a customer, and the customer goes to the Plugin Lens website, redeems that code and gets the plugin for free basically on our website because he already paid at the developer's page. And the interesting part is that's not something that everybody wants, because once you launch your own web shop, you have to deal with credit cards not working, PayPal not working, frauds, returns, all that stuff. And we have several full-time employees that handle basically nothing else but support and web shop related issues. So if you want to do that, if you think you can sell that many plugins on your website that it's worth doing all this, that's fine. If you're a one-man or two-man show, and I think your time as a developer is much better spent in programming the next plugin rather than dealing with PayPal issues from somebody who may even do it wrong. Maybe your website and your plugin is not even the problem. Somebody else is just not really understanding how to do it. I don't think that's a job for a DSP developer to sort this out.
I agree.
Okay. You agree, Mark? All right.
Yeah, I've had some of these issues, like a bit of product support and people contacting you directly. You don't really want to say no, but some of the cases it's like 100% user error and a few hours wasted. But, always a happy ending because they get their stuff working. So it's all good. But I'd rather be designing plugins.
In our remaining 6 minutes, if you're looking at our outline, we're going to talk about schedule and acceptance, rights, and all the legalese, why you do need the lawyers at the end. So Philip and Francine, I leave it to you guys to summarize everything you learned in law school in 3 years and, 20 plus years of practice between the two of you. Okay.
I think go for it, Philip.
Oh, I was going to say Francine.
Well, we actually did a lot. We talked about exclusivity. I think that what we haven't talked about, Philip, you look over the list. What we didn't talk about is what we call the legalese. And we call it the legalese because Mark and Dirk would probably say it's the part that's not as exciting to them, but where lawyers really focus on is you're going to be asked to give reps and warranties about clean title to your IP, about the performance of your IP. There might be a section on acceptance criteria if you're licensing and technology for a company to embed in their product. There's going to be a lot of time spent, I think Mark already hinted at this, about what your obligations are for support and maintenance. File format updates, keeping up with all the latest audio standards. Dirk and Mark can talk about that if they want. There's going to be something called indemnification clauses. Anyone else can jump in anytime they want. Limitation of liability. If something goes wrong, what's the limit of liability on either side, the Goliath or the David side? And breaches of your obligations, choice of law and jurisdiction. Francine always wants England and Wales in every dispute, if there is one, hopefully never there would be, to be disputed in London or nearby, right?
Absolutely, yeah. I don't want to have to go far.
We argue for courts of US.
Yes, I think at this point it's important when we deal with these legalese. This is really kind of the airbag, what happens if something goes wrong. Yes, the contract is the backbone of whatever you're doing to protect you and to protect what you've built, but it's also very important to simply remember what you have agreed upon. And I often see this, that an agreement is really pulled out simply to remember what did we actually agree upon in this particular scenario. And that's why it's important to have an agreement. In addition to all the legalese that we include here, where of course you represent and warrant that whatever IP you're transferring or you're licensing to the other party is actually yours. And if it's not, and if there's a third party knocking and suing and then you will have to indemnify the other party for their losses in that particular scenario. Meaning you have to, the infringing, the party that didn't actually own the IP needs to pay. And
the EU and US have passed legislation very, very strict on data sharing. So personally identifiable information of customers, you can think maybe, oh, Dirk and Mark can just pass that back and forth. Is that true, Philip? Philip is an expert in this area.
Yeah, I do a lot of privacy-related work, both from a US perspective and also European perspective. Personal data is, any data that may identify you as an individual, or that may be connected to you as an individual if you're an identifiable individual, and that's a little bit of a complex definition. It's a huge topic, and it's important to be compliant, and it's a separate topic. Obviously, these agreements, you need to write exactly down what you want, but then you also have lawyers to look at it to see, is this actually legal or compliant? Privacy, EU privacy, California privacy compliant. If you think, nice, it's good to share customer lists.
We'll take questions on that because it's a huge topic. The last thing I would share, and then I want everyone to go around and do a last point, and then we'll go to Q&A, is assignability. It's really important to look at this clause and see what you can negotiate to make sure if you change the nature of your company, if you get acquired and you want to keep these contracts alive, that the rights within the agreements are assignable. Okay, clean ownership, we talked about that. Last tips, you want to go around in our final 2 minutes? Dirk, what have we left out?
No, I was going to say that since we're running out of time a little bit, there are quite a few questions actually I see in the Q&A section. So if you want me to answer and Mark to answer some of those, because some are actually addressed to Mark.
Sure. Francine, did we leave anything out besides, I was thinking trademarks, own your intellectual property, big topics. Anything else?
No, we haven't left anything out, but I think one of the points that I would raise is the last point. You use a lawyer, you can negotiate on the fees there too. Don't be afraid to negotiate with your lawyer. They're expensive, look at getting fixed fees, that kind of thing. Talking about limiting the time so that you know that you're not going beyond what you can afford. I think that's really important because it would break my heart for a small developer to kind of find themselves indebted to a lawyer forever when all they want to do is create plugins.
Yes, you have an absolute right to know what fees will be and try to set parameters so it's within your budget. Okay, Philip, anything that's in your brain that you forgot before we go to Q&A?
No, let's have Dirk and Mark answer some questions. And
all right, let's go. Thank you all.
There's a question to lawyers, that's okay too.
I can't see the questions, so if there are anything for me in particular, feel free to read them out. And
Dirk, please lead us.
Underneath your video, there's a Q&A tab. I actually answered two by typing, but I just said I'd be happy to reply. If you want, I can start while you read through some of the questions, Mark, that are maybe to you. The first one was that I saw was, what are some of the examples of high demands or crazy ideas that indie developers ask for in negotiations? And that could be anything from just asking an out of proportionally high cut that they want to get. Like if they want to get 90% of the sales, for example, obviously that doesn't work. We can't pay out 90% of what we generate in revenue if we pay for the whole distribution, marketing, support, Q&A, everything that just doesn't work. And then there's creative stuff, like we had developers that wanted us to model their hardware gear and made it clear that they absolutely want it nailed and it has to more or less phase cancel the hardware. Otherwise, they wouldn't give us the approval to even let the plugin be released. But they refused, they told us they would not give us the schematics for the units and we can't look into the unit. And I said, well, how are we going to model your unit to a degree where it phase cancels the hardware if you, on the other hand, don't even want to share the schematics with us, under NDA, of course, so we would never share these schematics with anybody else. And that's some of the unusual stuff that we get. And then an interesting one, I think here from Jamie, he or she, I don't know, is asking if I could talk about the numbers a little bit, the ballpark numbers. And I guess these are very common numbers. I mean, there's a difference between a pure distributor who will maybe charge you somewhere, I guess, between 20 and 30%, maybe for just the distribution part. What we bring to the table, we charge for definitely, is Q&A. Mark spoke about this in the beginning. We make sure that the plugins are really going to work on most systems before we launch them. And then marketing expenses and also DRM. I mean, if you're signing with Plugin Alliance, we're not in the business of offering copy protection, but we do have our own DRM system. And so basically to make sure that people can use one installation manager and it's one flawless process to download all the plugins and try them and buy them. And that, of course, I see other companies that charge separately for this. With Plugin Alliance, it's a flat fee. But I guess somewhere between 30 and 50% is really what you make as the developer in cases similar to what we do. And then there's completely different cases. Philip mentioned it. Sometimes we just buy a plugin. We pay 10,000 or 50,000 or whatever the amount is, and then we own the plugin. And sometimes it's a lifelong royalty share.
All right, there's a very hard question in here. There's so many, there's good questions. Is there a price point at which you start using a lawyer? A contract price point?
Okay, I'd say definitely use lawyers all the time. But it's, like you said, it's to do with when they get involved. You want to be able to negotiate most of the stuff up front. You should have a good idea of what you want and also kind of limit your expectations. Like Dirk was saying, some people might have outlandish ideas. Other people are much more bread and butter. We want the distribution. We want the tech support. We want the QA. We want the license management. We want good marketing. And we just want to concentrate on plugins. I don't really know what kind of crazy stuff some people ask for. I can just imagine. But like you say, once you've kind of like got a good gentleman's agreement between yourselves, then definitely go and bang it out in legalese, because that prepares you for the worst case situation. Because, you know, no one wants to think about those things, but they do happen. And when they do happen, you can't have I said meant this, you meant that kind of situation. You just have to refer it to the legalese and go, this is what we talked about, and this is what it's going to be judged at, and let's find a good resolution based on that language. So I would say you definitely want to. And also, you know, there might be stuff in these contracts that a distributor sends you that you don't actually understand, and it's not worth trying to interpret it under your own kind of skill set. You need to really find out what these terms and definitions mean. So, you know, you empower yourself along the way.
I would say the biggest mistake I've seen is when smaller developers haven't used counsel and they inadvertently are doing a licensing deal where they're licensing their technology to be incorporated in a larger product, for example, or exclusivity where they've given away more than they realized. And so they come up with another idea and they've given up rights in the underlying intellectual property, and I just am unable to extricate them from that contractual obligation. So really do be careful. A really good question we had, that's something maybe Dirk can answer from a non-legal perspective, is because you have this from the Brainwork's perspective versus Plugin Alliance, is the differences in someone who's negotiating technology to be built into a product versus a plugin, which is already completely done, and how you approach looking at those two different ways of working with the developer.
There's a few different options here. That a few years ago, we licensed some component for a plugin that was basically a piece of code, and we integrated it into one of our existing plugins that we were building. And so we paid a royalty share in that case, but a smaller number than if somebody like Mark is delivering a final installer, basically, that he and his team developed. That's a distribution royalty. The royalties for code snippets or even a logo deal, if we do, I don't know, a guitar amp or bass amp with MPEG and they allow us to use their logo, that's a smaller royalty than if somebody creates a complete plugin. There's just a difference there.
So someone was also asking about protecting algorithms, and those are unique issues about protection for algorithms. So we can discuss that differently, but some algorithms are considered more functional and harder to protect. What other questions in there in our last 3 minutes?
There's one here about, what's it called? How do you manage IP with developers and your team? So like with Adapter, because I'm coming up with all the product designs, I'm hiring freelancers or regular freelancers or specific freelancers to produce the code for the Adapter plugins and have it all made into one thing. So essentially, when someone's working for me like that, they have to transfer all the rights to the IP to me. And then basically Adapter owns these things cleanly, which is the easiest way for a company to function. But I've currently got a situation where one of my freelancers who worked on a specific aspect of a plugin that I did came to me with something they developed by themselves. And we're in the midst of negotiating a win-win deal on how to make this thing work. Because they've got a very interesting algorithm, but they didn't have a product design. And they didn't have any way of distributing it. They don't really want to be involved in that kind of stuff. They don't even want to build a plugin. So really, it's about crafting a really good plan between us and, working out what's the best kind of way to do it. Licensing splits, royalty splits, how long for, how is it going to be handled, what their responsibilities are with the plugin, et cetera, et cetera. So in the process of crafting that one out.
Okay, and then the last question that came through in the chat box was about whether you have an idea and it's not fully developed, and whether you can get funding, usually through some sort of contract, to build that out. And Francine, I think this is something that you've dealt with, and whether you're willing to work with companies that have great ideas and partially done technology to help them finish it up.
Yeah, absolutely. The answer to that would always be yes. Come and talk to us. One of the things you do want to do there, though, is make sure that you've got an NDA, because obviously you're telling us something that's unique that you've created. You need to protect that. So do talk to your lawyers about that. But absolutely, part of your negotiation in that deal will be what kind of support do you need in return for developing the finished product. And actually, maybe what you can do is look at deferring some of your sort of royalty payments in the future for a kind of upfront cost to help support you through the development phase.
Philip, any other tips there on that one? And Dirk, would you take a unfinished idea and help them develop it? Either one of you.
Dirk should take that one. I think he has a good idea thinking about this.
We meet people in different stages of their life also. For example, we have bought code from people who developed something really amazing but just didn't want to continue making plugins. They just wanted to do something else with their life, but they had a really cool idea and maybe even code. And if we see something that is really unique and it just needs a little bit of like a little push over the edge to get it finished, and sometimes that may be just as easy as paying a few $1,000s to somebody as an advance, that's possible for sure. And if somebody, of course, would pitch me with an idea, we get emails and Facebook messages every day from people who think they have the most amazing and unique idea, and then you Google and it's all out there already, and they need $500,000 to finish something. And so this is the outlandish part that Mark was referring to. Maybe that just won't fly. But yeah, if somebody has a really cool, unique idea and needs a little bit of help, we would be looking into that very carefully. And Francine just said the same thing. So.
Okay. Josh, do we need to wrap it up?
Okay.
Yeah, I think you had one more thing that you wanted to say, but after you say that, then yes, we unfortunately need to wrap it up. We have some fantastic questions from the audience, by the way, and it's quite unfortunate that we're not going to get time to answer all of them. Maybe also just dropping an email or a place where people can get in touch with you if they have further questions. I think that would be very helpful for people.
Yeah, the Google Doc you can use, Philip.
Yeah, I'm sorry, I didn't want to interrupt. Yes, exactly. So the Google document includes, I saw some of these great questions and I was really, flattered that there were actually legal questions involved too. Heather and I have provided our email addresses. For those of you on YouTube, you can also go on our website. It's www.RafterMarsh.com. You'll see the firm's name in the background of Heather and Francine. And we're happy to take these questions offline and also to jump on a call. No worries, we don't charge. Just when we pick up the phone, all of this we'll discuss. and happy to always jump on a call.
And on our bio, we mentioned other clients we work for. If we can do intros to those, of course, we're very grateful to Dirk for being here on behalf of Plugin Alliance and also Brainwork. But we do work with other clients. We're all here to help. Francine is a good Samaritan and probably would help as well, even though she works exclusively for Focusrite. So one thing I want to just go around and everyone do their last words, but you might be wondering why Francine and I have these logos behind us. We want to thank ADC for being very supportive of women in audio. In the past, when we've been all together in person, we've had gatherings supported by Focusrite. Ableton has been involved, Native Instruments, a bunch of other companies, and we really want to thank anyone who's out there encouraging diversity in our industry.
Yeah.
Okay. Final words from our panelists.
Thank you so much.
Yeah, thank you. And thank you to Pace for taking this over and letting us stay involved after Rolly. Thank you to Rolly for your help in the past. And Josh, anything that we've left out?
No, just thank you to yourselves, the panelists. Thank you, Mark, Philip, Heather, Francine, and Dirk for all of your time. That was very helpful. And we've had so much positive feedback from the people that are in the audience, as well as people in the YouTube live chat. And
we really are all very passionate about this industry. So we're here to help anyone, small developers, just let us know how we can help.
And if you have an idea, that's something I typed even into one of the questions and answers here.
Absolutely.
If you think you have an idea or business proposal, please feel free to reach out, I'm sure, to me, and I'm sure that the same goes for Francine and to Mark. If you think you have something that's valuable for either Focusrite or Adapter or Plugin Alliance, Brainworks, please reach out to us.